What's up, everybody? Welcome back to another episode of the Lawyer You Know podcast. And today, week 2 is about in the books. It's lunchtime when we're recording this, and I'm bringing my dad back on to get his thoughts on what happened this week. But more specifically, we're going to focus on the direct and cross-examination of Jen McCabe, how Judge Cannoni is handling Alan Jackson and Hank Brennan and the objections and the impeachment and refreshing recollection, and what he thinks the perception of the jury is with Jen McCabe on the stand. All that and more this week. Make sure you guys hit the like button. Let's get to it. All right, Dad. Another week in the books here for Karen Reed's second trial. We had a break with no testimony on Thursday. We had a half day on Monday where we had the Arca Daubert hearing where the judge cites a rule that's not even a rule that deals with what they're talking about. We've got deleted text messages, conversations over Signal, and we had Jen McCabe testify, and she is still being cross-examined now as Friday, probably through the rest of the day. Friday she'll be crossed. Maybe they'll get the redirect. I don't know. So much has happened this week. Where do you want to start with kind of your overarching thoughts?
Well, I think we can start at the very beginning of the week because it's they started out, again, we talked about this last week, in how they've changed how they're presenting the case, how Brennan has changed what's going on. In the first trial, they went chronologically. They tried to do everything in order of how it happened. In this case, Brennan, again, is front loading. He is trying to put the things before the jury that he thinks will cloud the jury such a way that they'll be so biased by the time they go into the other stuff that they're going to already think that she's guilty, and it's not going to matter what the other people say or what's going on. So you start out with the telephone guy or the cell phone guy. And the cell phone guy, in some ways, was good for the prosecution, but unfortunately, he was not all good for the prosecution. So, you've got to balance the fact that they're going to use some of the timing. The cross-examination of the cell phone guy I thought was real good. And I don't know if you want to go into specifics about him yet.
About Ian Whiffen, the Cellbrite expert you're talking about?
Yes, right.
Sure. We can talk about, I think one of the big things that came out with him was the timeline, especially when we're also bringing in Jen McCabe, who testified after him. I think that was one of the plans of the prosecution. Mark Betterow, who's another lawyer that I had on this week, and we kind of talked through it, and he was discussing how he thought Hank Brennan planned to bring some of the experts up before maybe some of the inconsistent testimony. So Whiffen testifying now, he thinks the reconstructionist may testify before some of the investigation, which I think might actually be helpful to Brennan, where you have maybe better witnesses that if the jury believes with their main opinion, then the inconsistencies won't feel like as big of a deal. But I think when we look at the timeline that they're going through right now with Jen McCabe as we're recording this, and what the Cellbrite expert discussed, the timeline was there's a lot of inconsistencies, especially when we find out that Karen Reed's phone connected to John O'Keefe's internet back at his house just a few minutes later, I think like 12:36, something like that. So according to the cell phone data, it seems like the Commonwealth was saying 12:31-ish was the time John O'Keefe died. Yet now Jen McCabe is saying, well, she said in prior statements that she hasn't really, given to the defense that she saw him at that time, saw the car out there, didn't hear anything, didn't see anything funny, and then even continued to get up and text message him and try to see if he's there all the way till 12:45, potentially at night, depending on what version of the facts the jury is picking up on as the defense cross-examines her. So, that timeline of the Cellbrite expert was really important.
Well, it was really important, but I got to tell you, I thought that he fell flat when it came to establishing things beyond a reasonable doubt. He, ideally, he's kind of a scientific expert. He's not really he wasn't there. He didn't actually witness. You put him on as a science guy, being exact, right on the point. He was anything but that. He talked about how you can manipulate the data and how he was able to manipulate the data. So you can't really rely on it. He talked about, well, it really says 2:00, but it's really 6:00 when they were talking about when they made that data search. And he talked about how that's manipulated. And yet other experts, and he admitted this, other experts who analyze cell phone data, they're just as good as his company, would have said 2:00 instead of 6:00. And then he talked about the temperatures. And yet he didn't really do a good job on the temperatures. Let me tell you why. We've had experts we've brought in to try to duplicate a particular situation, and one I can think of right off the bat was a cable snapping. Well, that cable snapping, you had to duplicate the exact pressures on the cable, how it pulled the same machine. And what our expert did is he got the identical machine with the identical cable and did the identical exercise on the machine to show how and why it snapped. This guy put it in the freezer. This guy did different, but you know what? He never really duplicated the actions that happened that night, because they talk about the body temperature, how that would have affected the cell phone, when he took the cell phone out of his pocket. And he admitted temperature affects it, but he never duplicated the exact situation we're talking about here to see how it would affect it. So he left a lot of gaps, other gaps. It really didn't put the phone at the exact spot, but within a certain radius of a spot. So he could have been, I think it was 10 meters, which is like 38 feet or something, that it could have been here or there. And again, we know from another case we have that they don't know the exact spot of your location of the phone, but they do like a circle around the spot. So they can tell you generally within these certain number of yards where your phone is. So he never really, really did pin it down. He gave them a lot of reason for reasonable doubt as to what can happen. So you can't really say that he did a fabulous job of pinning it down for the prosecution. We know from, again, the opening statements that we're going to hear that the prosecution is married to 12, 38, and 31 seconds, I think is
I thought it was 12:31.
Is it 12, 31, and 38 seconds?
Now I don't remember. I can't remember.
Yeah, it's something like that. But they're married to, they're going to be married to that because they're going to have an accident reconstruction expert that's going to say that this was from the automobile. They can tell this was the event that occurred. That was the striking of the body.
Yes, the final health activity on the phone was between 12:31 and 12:32. So yeah.
Yeah, right. So they're going to say that's it. But this guy wasn't very exact when he started talking about things. And he talked a lot about manipulating data and how things, this case apparently changed how they manipulate data. So I didn't think he was a great witness. I really didn't.
I think that the temperature stuff was a complete flop because he didn't even try to put it in the same conditions. But the importance of the Google search, right? Like I know you didn't watch a ton of the first.
I know what the importance of the Google search is.
Yeah. Right. So you're picking up on that, at least from the second trial, where if she did it at 227, that makes no sense. Why would you be searching that at 227 unless you put his body out there? If she's searching it at 6:00 in the morning, it's because Karen Reed asked her to do it. And so that makes a big difference. Now, he changed the tool and it's different now, but at least for his demonstration, it's the exact opposite of what he did with the cell phone temperature, but exactly what you're saying, where he tried to create the same conditions, opened up a tab, made the search, and it still reported the time that the tab was originally opened, not when the search was made. I did think that was an effective demonstration of what exactly you're trying to opine happened. And I believe either he said or maybe the prosecution made it seem like the defense's expert is not going to be able to do that. They're not going to be able to real time do that presentation. So we'll see if they do or not. I also thought cross-examination was effective where he said, that's after you made the change, right? And he's like, yes. So now it's after their company made the change that he was able to do the presentation real time.
But he did give the other expert credibility. He said they are just as credible as we are.
Well, that's not the other expert. That's another company. The other expert is one of the guys that reached out to him, and the other expert uses multiple companies, including his competitor, where you're right. He said they're a completely legitimate company, and they still would report that the search was made at 227. And I guess, according to Ian Whiffen, would just be completely wrong.
Right. So again, that's why I've said his whole testimony, if I was a juror, I couldn't possibly convict somebody on what that guy was saying.
Yeah. I mean,
there was just,
it's a piece to the puzzle where I think it did show it can help their timeline if they stick with their timeline, if it wasn't for Jen McCabe. But if they stick with their timeline, I do think it can help with the time of death. Theoretically, could she get back to Meadows in 5 minutes? We'll see. They're going to talk about that, which is John O'Keefe's car. And it does put him at least in the circle. The circle does cover the lawn. Now it covers part of the house as well, but it does cover the lawn. So at least I understand where they're getting something from that. I'm trying to think. Was there something else about him? I mean, is that pretty much it about him, or do you want to?
Right. No, no.
All right,
It's just that there are so many things that he wavered on and admitted that he would waver on, and it
all right.
wasn't
Let's go to
exact.
Arca next. Judge has him up. Hank Brennan. What do you think about Hank Brennan's demeanor and the way that he cross-examined Arca during that hearing?
I don't think you're going to see the same Mr. Brennan when he's in front of the jury.
Yeah,
So keep in mind, there was no jury. He was being an SOB to those guys, but he was trying to see if he could get something out of them, and he got nothing out of them. So he tried to push as hard as he could. The Arca witness was a very good witness, kept his cool, didn't get rattled, was very calm and very sure of himself. And he wasn't worried about his answers. He wasn't worried about what he's going to say. One thing I will say, though, was that was a hearing that turns out to be a big zero and didn't make any difference. I think the judge made a mistake. I mean, again, she's not going to get reversed on it, but she made a mistake by not letting the defense speak about Arca in their opening because of that.
yeah,
I think it shows that she did that, and it was a knee-jerk reaction by her, and she almost came out and admitted she was wrong because it turned out to be nothing, and she's going to let everything in anyway, and it made no difference whatsoever. So
yeah.
that
That's a
was a
good point.
mistake.
That's a good point because she cuts off Wolf after an hour and 45 minutes. She gives him 5 minutes with Rentschler, where if he was really important and we need to make this decision and we might actually strike these witnesses, we are so close to striking these witnesses that you can't even talk about them in opening. Like, that's
Right.
crazy to me, especially how she cuts these witnesses off. She doesn't even let the defense argue after she says, answer me one question, Mr. Alessi. And then, by the way, she cited, I think, the wrong rule that I read out on my stream. And even the right rule that she meant and she quoted still doesn't say what she needs it to say, which is communication between experts and lawyers. Everything she focused on was communications and documents between clients and lawyers, which is not the same set of rules when it comes to experts. And then she tells Alessi, you're going to win, basically, so sit down. But if that was the case, it's crazy that they weren't allowed to talk about it in opening. And it's so frustrating. But I think one of the reasons it's not going to get overturned on appeal, because I think Jackson handled it perfectly. He said you're going to hear from experts. He didn't mention Arca specifically, but I think he made a pretty good point that they're going to know he was talking about Arca once they hear him eventually. What do you think about the deleted text messages using the Signal app, which is encrypted and you can't keep track of it, for lawyers to talk to experts?
On one hand, I think, gosh, sounds like a pretty good app. But on the other thing is, I do think that communication between the lawyers and the experts, you should keep track of it. I don't think it should be automatically deleted, which I think this does.
Well,
This
here's my
doesn't
question.
save it, right?
We do, the vast majority of our discussions with experts is over the phone.
Absolutely, for a
So there's
reason.
no record of it. So
Right.
so what's the difference? I have been doing a lot of research because at first it does sound bad. I'll be honest. At first it sounds bad. My inclination, probably because I learned from you, is exactly what you said. But as I look more into it, what's the difference between that and a phone call? Like, I really don't know. And it almost seems like the rule is out of date and we've got to figure out how to write these rules better. Like, do we want to just make that stuff inadmissible, or are these types of apps not allowed to be used by lawyers? Like, we got to figure that stuff out, because as technology continues to
Well,
grow, I don't see the difference between that app and a phone call, because both of
well,
them,
it's
you're relying on the lawyer and the expert to be honest. What did you guys talk about? Well, let me tell you what we talked about. Here's what we talked about. Are you saying lawyers lie when they talk about what they said over the phone? So what's the difference between a text through Signal or a phone conversation?
Well, a couple things. One, it's no surprise that the rule is not keeping up with the technology. I mean, that's a constant. Trying to keep up with the technology is almost impossible when you really think about it. But secondly, is the difference between that is it was in writing as opposed to oral. And I do view things in writing different than I view oral communications. And so it was a written communication. You know, in the old school, I guess I'm old school, I think you should keep track of your written communications. But the new rule and the way things are changing, yeah, you know, it may get changed. You and I have both sat on rules committees, and we know how rules get written. And you write a rule, especially a rule dealing with technology. By the time the rule gets through committee and gets to the Supreme Court and gets approved and gets
It's
published,
so annoying.
there's new technology. So the rule is already old by the time it gets there.
Yeah, it's so annoying. It's so annoying. Did you? What did you think about the rule that she cited that had nothing to do with it? Any other thoughts on how she handled the Arca hearing? Okay.
No, I mean, her ruling was right. You know, there was no reason not to let Arca in. The ruling was correct. I just think it's a shame that she kept them from doing it in opening statement when you really
Yeah.
see that hearing.
Yeah. Yeah. I agree. Okay. Now we'll get to kind of the highlight, biggest part of the week, which was Jen McCabe's testimony. She testified the first trial. She had a pretty different look, pretty different demeanor. It definitely felt like she was a part of the first trial, like she was defending herself. I keep using the phrase a dog in the fight, which is a bad, no pun intended, but it really felt like that trial number one. Trial number two, she's much calmer, especially on direct. She seems like a soccer mom who just wants to come and help out. And her best friend, John, this happened to him. And she is doing a really good job. There have been points, especially on cross, where she starts to get riled up a little bit. But overall, focusing on direct, what did you think of Jen McCabe as a witness?
Let me tell you what I did because I'd heard the same thing that you were just saying.
Mm-hmm.
I went back and listened to just some snippets of her first trial testimony, just to see if there was a real difference. And boy, was there ever. It was obvious to me that she had cleaned her act up. Now, she denied anybody told her to clean her act up. When they asked her, oh, did they tell you to change your demeanor on the stand? She said, oh, no, they never told me that. But they must have handed her a tape of her prior testimony and say, hey, take a look at this and tell us what you think. She probably looked at it and went, you know what? That was not a good look for trial, and I need to calm down and keep myself under control. So she had a totally different look. You're right. She was calmer. She was more polite. She listened to the questions. She answered them as completely, in fact, far too completely, and we'll get into that. But she definitely had a different demeanor on the stand this time. As far as the direct goes, she did well on direct. I thought that she was. Let's face it, she's really important. As far as a fact witness goes, not the experts and all that stuff. I don't know if there's anybody more important individually than she was. So she came across well on direct. She answered the questions, and I think she did a good job on direct. But again, that was
Well,
before she gets crossed.
right,
But
right.
I thought she did a good job on direct.
And before we get to cross, she almost made herself the most important witness. And that's been kind of something interesting that's been developing. She's talking to everybody. She's writing the timeline. She's meshing things together. She's telling people the defense wants you to believe. She's telling people what to say at the grand jury. She's keeping tabs on Peggy O'Keefe. She's keeping tabs on Carrie Roberts. She's keeping tabs on everybody. And she is kind of the center. And the defense really is trying to paint that picture with other witnesses as well, but definitely on cross. So let's
Oh
get to
yeah.
cross examination now. Day one, what was your opinion of Alan Jackson's cross?
Okay. And I have to apologize. It's hard for me to say which was day one and day
Well, the
two or day
beginning of his cross,
three
initially of his
because
cross.
they all kind of. But
Sure.
here's yeah. So his cross was designed to show exactly what you were saying because they have to show number one they have to show the family connections, the friend connections. They have to show some reason why there may be something that smells in this case. They may not be able to say, you know, this particular individual is the one that killed the victim
Yeah.
in this case. They might not be able to say that, but they have to be able to give the jury an impression that there's something wrong here. Something happened and there was some mistake. And so she becomes the basis of that during cross-examination. So number one, what's her family connections? It's her sister, her brother-in-law there at the house, Albert, right? Right?
Yeah.
Right. The brother-in-law at the house. They talk about the dog that comes up during cross-examination as well. She knows all these cops that she's talking to, and she doesn't just know them. I mean, she really knows them. I think she dropped her kid off at the sergeant's house and went in and maybe used the
Not her
bathroom
kid,
at
her
the
friend's kid,
sergeant.
but yeah. Yeah, I mean, they're all
Yeah, yeah,
interconnected for sure, and he made that
yeah.
point for sure on Cross, but generally speaking, like, how do you think he did? How do you think he did the initial part of Cross? That's, I guess, my main question. As a
I think
lawyer.
as a lawyer, I think he did well. One of the things that was really important in the way he did it, and again, there are methods, and he did an excellent job. He didn't just jump to the key question. I like the way he built up to the key question. For instance, he would say, "This was really important to you, wasn't it? You wanted to make sure you remember this, don't you? How significant was this in your life? How shocked were you when you heard this?" He built all this up until you get to the final question, which was, "Well, then why didn't you tell the grand jury? I hit him, I hit him, I hit him." But before he got to the key question, he spent 10 questions building her up to that point so that the jury could know the point that no way in the world would someone who thought those statements were that important would have forgotten to say it to the grand jury. So and he didn't do that in just that one issue. That's the one that comes to mind. But he did it on several areas of cross-examination where he would build her up, if you watch it, step by step by step, so that the jury knew that this is not some mistake that she made.
Yeah,
And
yeah, I think.
I think that's what you meant when you were asking me about how he did. That's what he did it, and he did a really good job of it.
Yeah, I just mean stylistically. Like, what did you think of his cross? Did you
Oh,
think it
good,
was good? Did you think it was bad? Did you think he struggled
good.
here? Did good here?
No,
One of the things I thought he struggled with a little bit on day one, I thought the beginning was awesome and how he set it all up. But once they started to get into trying to impeach her from some of her prior inconsistent statements, and she just kept saying, I don't remember. He was refreshing her recollection. She was saying, well, that doesn't help me remember. I just see what's on the paper. Um, that seemed clunky and like a little bit of a struggle to me, especially because the judge seemed to be helping the witness with some of her instructions and some of the things she was saying. What is it like when you see the difference between impeachment and refreshing someone's recollection, and how can lawyers deal with that? Like, what is the difference, and how do you deal with a judge forcing you to refresh recollection over and over again when you're trying to impeach a witness?
well, one of the things I noticed when he was doing that was he didn't always have his citations ready. He didn't always have his page and line numbers ready, or he would give her a page number and not tell her the line number. So he was not totally focused, or at least he didn't have it all written down the way he should have when he asked the question. That's one thing. Second thing I noticed, I thought the judge was unfair. She has done some things, and during the cross examination, I thought she was unfair. When he would ask a question, the witness may not necessarily answer the question or answer really say, is this a yes or no question? Or she would let the witness go off on a tangent and wouldn't really rein the witness in. Or she would tell the witness something like this. He would ask the witness a question. The witness would be thinking about, talking Ms. McCabe, would be thinking about the answer, and the judge would go, "If you know the answer," and basically giving the signal to the witness that you can just say, "I don't know," and
Not even just
therefore give.
Yeah,
Go
not even
ahead.
just if you know the answer, but do you have a memory of that today? Which is not even
Right.
the right question. You can refresh somebody's recollection to something that they don't remember today, but after reading that piece of paper, they remember it. That's the whole point of refreshing your recollection. You don't have to have an independent memory of that day. So, and that's what I want to talk about with you specifically. So, tell me the
Okay. All
differences
right.
between
I'll get
refreshing your
back on.
recollection and
uh,
impeachment. Let's focus
I'll get
on that.
back on that point. Okay. Refreshing recollection, that only deals with an issue where someone doesn't remember something, and you have something, and it's anything that can help them remember the particular event or remember what the answer is. And by anything, I mean it could be a dead fish. If a dead fish would help someone to remember the answer to a question, you can show them a dead fish. It doesn't matter what you show them, you have the right to show them anything. The person can say, "No, that doesn't help me. It doesn't refresh my recollection." But you have the right to show them anything you want to help them refresh their recollection. That's refreshing the recollection.
Mm-hmm.
Now, impeachment means they gave a different answer at a different time, and you want to point out the fact that they gave the answer. Did they say something to the grand jury that they didn't say today or different than what they said today? Or did they say something in that prior trial that is different than what they're saying in this trial? That's impeachment. That's an inconsistent statement that you're showing rather than trying to refresh their recollection with something. So
But like when you
those are the
want to make a
differences.
distinction and you want to choose to impeach, do you have to refresh the recollection?
No,
Right. And that's the issue.
you don't have to. No.
Right. That's the issue. She's forcing them to basically refresh her recollection and ask the questions in a way that refreshes their recollection versus just impeaching them straight up. And that was where I thought Jackson struggled at the end of day one. But if you've watched the beginning of day two, which is today, Friday, we had Thursday in the middle, he has changed that completely. He is going with, you didn't see him at 12:45, did you? And whatever answer she gives, he impeaches her. Do you deny saying that? That's a great question that he started to ask this day as well on Friday. Do you deny saying that you saw him at 12:45? Well, no, I don't deny saying it. I just don't remember today, because you cannot remember something that's very different than denying you said it or saying, I didn't say that. What are you talking about?
I tell you another thing he did, but the judge stopped him and sustained the objection that I thought was improper, was he said, did someone tell you that another witness said this?
Yeah.
And that's a certainly proper question, because if she was told something, then that affects her testimony.
And it's not even about, it's not hearsay because it's not the truth about what they told you. It's just, if they are telling you something, is what we want to know, because the effect on the listener. That's the
Right.
exception to hearsay there when you're asking that question. And again, the judge just keeps not allowing him to go forward. So
Right.
that's something I noticed. Did you notice any change from day one to day two in his cross-examination?
Well, like I said, I thought you're right. Day two, it was a smoother cross-examination. I thought he did a better job, but he also, I think, was hitting the more important parts on day two. I think he was moving into the really important stuff so they could really hit her in day two. And so I thought day two was a more important day, and that might have been why it went smoother, is because he was just leading up to day two from day one. Another thing she did, and I can't remember if it was day one or two, I think it was day one, where she would said to the jury, I like remind the jury that what the lawyers say is not evidence.
Yeah.
That was ridiculous. She didn't do that when Brennan was saying stuff, but she did it when when Jackson was saying stuff.
Oh, yeah.
That was totally improper. I mean, that really was ridiculous. Another thing she does is she will, when he's trying to make a point, and again, Jackson does it by little baby steps until he gets to his hit. Mm-hmm. She'd stop him and say, hurry up, or, let's get this done. Basically, that telegraphs to a jury, what Jackson's doing is not important. So let's move on to something else. Whereas Jackson had a point, and he had every right to make that point, but she was cutting him off, or trying to cut him off. He kept going, but she was trying to cut him off and say, let's hurry this along, because what you're doing is unimportant. She was inserting herself way too much this time.
And it's really frustrating too when a judge is doing that and there's really nothing you can do about it, because you're just sitting there as the lawyer trying to ask your questions. I mean, you can keep pushing and you can keep doing it, but when you start fighting with a judge in front of a jury, you lose, because the jury usually likes the judge. The jury usually trusts the judge. The jury's usually much more skeptical of the lawyers generally, but even more so the defense lawyers, much more skeptical of the defense lawyers. So it puts you in a really tough spot. So that's another thing. In your experience, how have you dealt with judges you feel like are being unfair, either making comments like, the questions are not evidence, making comments like, let's hurry this along, making comments like, objection, Your Honor, that answer was argumentative. And she said, you asked an argumentative question and she answered in kind. That's literally what she said. So comments like that, how do you deal with a judge like that?
Well, unfortunately, there's not much you can do about it. You can try to have sidebars, and you can try to point out that, Judge, you're trying my case for me. Let me try my own case. Judge, you're inserting yourself into my cross-examination. You can try to say that. 9 times out of 10, that doesn't have any effect. But you can try that because once in a while it does good. Otherwise, you have to live with it, number one. Number two, you can't be intimidated by it. Even though she's going to jump on you, you still have to ask that question. Even though you know she's going to make that comment, you still have to ask that question because you just can't let her intimidate you and can't let her control the way you try the case. It's your case. You try it the way you want to try it because that's your right to do that as a
Yeah, and you
defense
have
lawyer.
to, I think you have to make the comments on the record at sidebar. You have to keep doing it so that she knows. Because I mean, she was even doing it sometimes. I noticed today Hank Brennan was objecting a little bit more, asking for instructions, but she was doing it without even an objection. She was doing it
Right.
without an instruction. One of the things I've noticed people complaining about, I'll give my thoughts on it after, I haven't really talked about this at all, is when they ask a question and she does something like, is that your memory? Do you remember it? I'll allow it. Are you lying? Whatever it is that she looks at the witness and questions the witness, people are saying, oh, that's not right. She can't ask the witness questions. Isn't that unlawful, unethical, illegal, whatever? What are your thoughts about that?
All right. It is not illegal or unlawful, whatever you want to call it, for a judge to ask questions. A judge does have a right to ask questions. The idea about giving the judge that right is for the judge to clarify something or for the judge to help the jury, not for the judge to insert herself into the trial or try the case for you. For instance, I don't know if I can even think of a good example. Oh, I give a good. You ask a witness, isn't it true that Joe Smith said, I hit him? And the witness goes, yes. Well, the judge can say, excuse me, could you give me a date and time and place in which they said that? So that it clarifies the statement as to date, time, and place. Those kind of things, so that it's clarified for the jury. Is what a judge is supposed to do if a judge asks a question. Not, again, try the case for you or indicate some kind of bias or criticism of the defense lawyer while the judge is asking the question. And that's what some of these things are telegraphing to the jury.
Right. I don't have a problem at all with the judge asking a question, clarifying what she thinks the lawyer's asking that the witness may be misunderstanding. The judge can just ask questions on their own if they want to of some of the witnesses to try and clarify things to the jury and bring out the truth and enforce justice and make sure things are getting out appropriately. I don't have a problem with that at all. The problem is just like you're saying, when she's indicating to the witness, do you remember that as you sit here today, exactly how he's saying it? I mean, she doesn't quite say it that way, but indicating, especially to Jennifer McCabe, you can say, I don't know to this. You can say, I don't remember to this, which leads me to another big point. As you try cases and you have a witness that continuously says, I don't know, I don't remember, I don't recall, I'm sorry, I'm doing my best, with all these prior statements, including just 1 year ago, telling cops certain things, testifying before the grand jury, testifying at a prior proceeding, we're not going to call it a trial. How do you deal with that as a lawyer? What arguments do you make in your closing argument when you have these witnesses that are absolutely positive about certain facts that they may have never said before, but say, I don't remember over and over again?
You keep asking them the question and let them say, I don't know or I don't remember, because when you're making your closing argument, if they only remember the facts that help the prosecution against you, the defense lawyer, and then they don't remember any of the facts that help the defense, that's a good argument. Why is it that they remember this, but they don't remember that? Why is it that they remember what happened 2 years ago, but they can't remember what happened 6 months ago? Because it helps you. You keep asking the question, and you really can use that in your closing argument. And that's what you do in the closing argument, because you also can make them look ridiculous. But you can ask so many questions about things like, did the sun come up on June 3rd? And they go, I don't remember. You can make them look ridiculous. And that's also a good thing to do.
Even with Nuttall, the first responder that was the first witness, he said he thinks his memory has gotten better over time. And it's better today than it was 3 years ago when all of this happened. It's better today than it was a year ago. And that's just illogical. Like most jurors are going to see right through that, that is not the case, not how it's going at all. What have you thought? Go ahead.
McCabe is it's a prime example. Not only did she say, I don't remember a lot of the things that she said, he showed some video. Oh, that happened today. You haven't covered today yet, I know. But
Go ahead.
But he showed some Jackson showed some video today and goes, "Who is that talking to the police officer?" Me. "Who is the one talking the most to the police officer?" Me.
Yeah.
So all the video shows her and the police together more than anybody else, yet she couldn't remember the conversation. So it just made her look bad and hurt her credibility because he had that video of the
Mhm.
scene, the
Yeah.
dash
Yeah.
cam, I think it was.
Yeah, and that's the point of kind of making her the center of everything, the centerpiece of this case, the really important part of this case. What have you thought about? Because I think you said it was a big mistake for him not to mention Proctor in his opening for the Commonwealth for Brennan. What have you thought about him not mentioning Proctor to any of these witnesses either? Basically, he's the one interviewing all of them. He's
Yeah,
the one
yeah.
gathering things. He's talking to first responders. He's talking to McCabe, and Jackson brings him up over and over and over again. What have you thought about that?
I think if he loses this case, and I think there's a very real possibility that it's going to be a not guilty after seeing what I saw this week, it's because Proctor is going to be the biggest stinky fish in the case. He's got to have a stinky fish because why would McCabe not say I hit her, I hit him, I hit him 3 times to the grand jury? Why
Yeah.
is it that she would uh, be looking out the window and not see the body laying and not covered in snow? If you look at the timelines for the phone analysis, she was looking out the window right when the body should be laying in the snow. Why didn't he? There's got to be a reason for this. We may not know what the specific reason is, but it's got to stink. They have to prove a big stink to the jury. They
Mhm.
just can't say people made mistakes. It's got to stink somewhere. Proctor's going to be the big stink. When they put Proctor on there, this disgraced guy, when they show his text messages, he got fired. How horrible a guy he is. What a real slimy guy he is. Proctor's going to be the big stink, and they're going to say this all just stinks so bad, that we just can't possibly find somebody guilty beyond a reasonable doubt when none of this has been explained by the prosecution. So I think Proctor's going to be a big Achilles heel for him.
Yeah, I think that him just continuing to act like he doesn't exist is tough. What have you thought about the presentation of the evidence now that we're 2 weeks in? We haven't really talked at all about the investigation. Proctor is one thing, but the taillights pieces being found for weeks and weeks and weeks using red Solo cups. We're just now getting into some butt dials. But what do you think about Brennan kind of pushing all of that back later in the case? Do you think that's a good strategy?
I think it's a necessary strategy. Like I said, he's trying to front load this. He's relying a lot on this. I hit him. I really think that really is the centerpiece of his case, because I think everything else is going to be subject to, like, for instance, we know we're going to have conflicting experts. We know that we're going to have conflicting evidence. We know we're going to have all this stuff. So they have to believe when she said, I hit him, that she meant I hit him.
Mm-hmm.
If they don't believe that, then Brennan has no chance whatsoever, because everything else is going to be subject to uh, a little variance. So you can manipulate this. This expert says this expert says that. But how can you possibly say that she meant anything but I hit him? I personally think there is a lot of question about whether she said I hit him and what she meant by I hit him or did I hit him. But they have to believe those statements. And that's why Brennan's putting them on right in the beginning. Because if they don't believe that she meant I hit him when she said I hit him, then the case is over.
So there was a case called Richard Allen, and it lasted forever and ever. It was years and years old. It was a cold case. They end up arresting him, and the big thing that they put him in horrible prison conditions. And the beginning, he denied. Eventually, he has these confessions over and over again, saying he did it. Prosecutors say he gave specifics, things like that. Confessions can be very powerful. The defense argued it was a false confession. It was because his mental state was broken, things like that, right? But they have it over and over again, and they have it in a way where they had him saying he did that horrible thing specifically. This confession that the Commonwealth is trying to go with here, that is a and the Richard Allen case has so many issues that we can't even begin to get into it today. I'm just specifically focusing on confessions that the defense fully believes are false confessions, but the prosecutor got to get up and repeat it over and over again to the jury, and he ends up getting convicted. Do you think this I hit him, I hit him, I hit him is going to be when you're comparing it to confessions you've dealt with as a prosecutor and a defense lawyer, where does it rank on guaranteed great confession early on from a good police interrogation to not even close to a confession and they're trying to twist it into one? Where on that spectrum do you think this lands?
I think it lands on the very weak part of that spectrum. I hit him. First of all, they all talk about what a panic state she was in when she said it. They all talk about, they took her to the psych ward or something at the hospital, I think called a Rule 12 or something like that, that she was, involuntarily taken to the hospital because she was so messed up. What you're talking about, the Allen case, I remind myself about another case where the police, in an interrogation room, they forgot to turn off the tapes. So the tapes revealed that they told the guy, listen, just tell us you committed the murder, we'll let you go. So the guy said, I committed the murder. But it was on tape that they told him that they let him go if he just said that. So I don't look at this as a very strong confession. I don't even look at it as a confession. I think I look at it as a hysterical person making a hysterical statement, feeling a lot of personal guilt because the guy, it's her boyfriend or husband. I think she referred to him as the husband at the hospital. I don't consider this a confession. And I don't think the jury's going to either unless the prosecution has some really good evidence, which right now it doesn't look like they have, that's really solid that she did it.
So not even knowing for a fact, really, because you didn't watch everything on the first trial, what's coming with the investigation and with the defense. How far down the road, 2 weeks in, because there's only really a couple weeks left of Commonwealth evidence being presented in their case in chief, how far down the road do you think they are in proving beyond a reasonable doubt that Karen Read committed a crime that night?
I think they have a long way to go. Yeah. I still think they have a long way to go.
It's possible. We'll see what the experts say. We'll see what the other witnesses say, but they're not making a ton of headway, in my opinion, unless you truly believe she confessed and said, I hit him, which Jen McCabe in her cross today, she really kind of turned it back on to last trial. And she was like, well, no, I said it because she said, I hit him. She had a cracked taillight and John was left there and she knew exactly what she was trying to shove all the evidence in as to why she thinks it was Karen Read. And unless you're right on board with that, it feels like they've got a long way to go. But in fairness to Brendan, he said all the data and the science is with us. So we still have to wait for a lot of that data and science to come out.
But we also know that he's not right. All the data and science isn't with him. We know that. And that's why you just said it. And that's why I said it. They've got to believe that the I hit him is a confession. They've got to believe that that was a true statement. Otherwise, they've got no case. And I think Brennan knows that. And I think that's why Brennan put it in now, because this way, when everything else comes in, hopefully the juror is always reminded of her statements. I hit him, I hit him, I hit him. So that those statements are all beefed up now by the science. The science isn't going to convict her. It's going to be that statement and then the science supporting that statement.
Yeah, and I think that's how it should be, right? It should be the proof should be in the pudding. The science, the data, the testimony, it should all line up. We should be sure when we convict people. We should be nearly certain, as close to certain as you can possibly be before we convict anybody. Any other thoughts on week 2 of trial or what you're looking forward to here coming up on week 3?
Well, I am looking forward, and I'm sure everybody else is too. I'm looking forward to the Arca witnesses, and I'm looking forward to how the Arca witnesses handle the Commonwealth's expert, because they didn't have the Commonwealth's expert report before. So I'm looking forward to their rebuttal of the Commonwealth's expert as well. I think that'll be interesting. I didn't really watch the Arca witnesses in the first trial, but I watched the Arca witness here Monday, right? Was it Monday?
Yeah.
Monday. Arca witness on Monday. And I thought he was an excellent witness. He was cool.
They're really good. They're pro.
Calm.
They're like we have in every car accident or truck accident case.
He was wonderful.
Yeah, that's exactly what they are. The first trial, the thing I was looking forward to the most was the Commonwealth's accident reconstructionist. Because we had heard the federal investigation. We kind of knew what Arca was going to say. They did a Daubert hearing on it. But I really wanted to hear what the Commonwealth's accident reconstruction expert, and it is potentially the worst law enforcement expert I've ever seen testify at trial, let alone trying to be an accident reconstructionist. So they've got a new one. No surprise. Good move by them. That is who I am most looking forward to on the Commonwealth side. What is that accident reconstructionist going to say? How is he going to fit it into their timeline? How is he going to make it work with where the taillight is compared to the injuries on John O'Keefe's body? That is by far the witness I am most looking forward to. Without that witness, to me, it is impossible to prove this case beyond a reasonable doubt, because if there was no collision, there was no crime here, at least how they're leading up. I don't think a juror is going to convict unless they obviously believe there was a collision.
And there has to be, because the taillight is the only evidence of a collision. So, the taillight and what happened to the pieces of the taillight and how it was broken, that's the only evidence. As far as I have heard, there's no scratches on the car. There's no blood on the car or anything like that. So it's all taillight. And this new guy is the guy that found that time, that 12:31 or 12:38 time, right? He's the new guy. I don't think the other guy.
The new guy.
Their new accident reconstructionist.
I don't think he found it. He got it from Ian Whiffin's data.
Oh, okay. Because they didn't have it last trial, did they? Did they have that minute?
They didn't say that time. They had a time frame where they thought it was based on what Jen McCabe said, but it does not line up. It was very vague the first time, which is one of the problems, is they did not have a specific time. This time, they're saying they did say it was before 12:36, so they had like kind of a time range, but not as specific as this time for sure.
That's what I'm saying, because that's what I heard. This specific time they did not have in the last trial.
Yeah, definitely the timelines are changing, and the Commonwealth has to change it. Their witnesses have to change it. That's why Jen McCabe is trying to say so hard she doesn't remember getting up. Last time she was like, I kept getting up and going to the door and checking. Every time I check, I text him, where are you, where are you, where are you? Which is even more of a problem, where why wouldn't you walk outside and see if you keep texting him and you thought he's there, but he's not coming in? So that was another kind of weird thing.
And didn't she also this time, as opposed to last time, wasn't she also vague on some text that she made after he died?
She's been vague on a lot of things this time.
Yeah, all that stuff. So she's obviously just trying to convict Karen Reed, and I think that also came out during the cross-examination.
Yeah, and it came out all over everything the first trial, but there have been moments and flashes of it this time. So we will keep an eye out. Thank you for your input, Dad. We'll get more of a breakdown next week. See how week number 3 goes on trial number 2 for Karen Reed. Hopefully you guys enjoyed the episode. Hit that like button now if you haven't. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.